Ang next discussion natin will be on the nature and effects of obligations. So, Chapter 2 starts with Article 1163. Article 1163 provides that every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law of the stipulation of the parties requires another standard of care. Now, as you can see, or as you can observe dito sa Article 1163, it talks about the real obligation, the obligation to give. Kasi every person obliged to give something, so obligation to give yan. Real obligation. Now, ang pinag-usapan dito is a thing, something, to give something. Now, ano ba itong pine-pertain ng something na to? Now, take note, itong thing na to, kung ano yung kanyang classification, it is very important. Kasi pag ito yung classification niya, iba yung mechanics para sa kanya. Kung ito naman yung classification, another classification, iba rin yung mechanics para sa kanya. Pine-pertain natin dito is the difference between a specific determinating and a generic indeterminating. Now, let's talk about specific or determinating. So, from the word itself, alam na natin, specific, very particular. Narrowed down siya, di ba? So, the above provisions refers to an obligation specific or determinating. Now, ano ba ang proper definition ng specific or determinating? Basically, according to Article 1459, a thing is said to be specific or determinate, particularly designated or physically segregated others of the same class. In layman's term, napipinpoint mo kung ano yung bagay na yun. Ganon kasimple ang definition ng specific or determinating. Let's say, wag mo na. Diretso muna tayo sa meaning ng generic or determinate para ma-compare natin sila. So ito, pagdating naman sa opposite niya, yung generic or indeterminate, from the word itself, generic, indeterminate. Sabi dito, a thing is a generic or indeterminate when it refers only to a class or genus to which it pertains and cannot be pointed out with particularity. So yan, opposite na opposite siya ni specific determinating. Now, kung tatanungin kayo, sabihin natin, eto, Poco M3 phone, specific or generic? Generic. Kasi, yun lang eh. It refers to a particular class. It refers to a class or genus. Wala siyang specificity. Hindi siya narrowed down. Hindi siya pinpointed. Pero, pag sabihin ko, etong Poco M3 cellphone with serial number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Yun, specific na siya. Depende sa pagka-designate sa kanya. So take note, excuse me sir, pwede po bang recorded to? Hindi ibang ginagamit kong software sa pag-record. Third-party software. Char, advance. Saan na yun? Na tawag dito. So, wala tayo. So yun, saan yung sabi ko? The moment na binigyan mo ng particular designation itong cellphone, sabihin mo, ito cellphone to ni sir. Itong cellphone na may serial number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. The moment na binigyan mo siya ng particular designation, yun, you can consider it as a specific determinating. So, ganun kasimple. Basta ma-pinpoint out mo, automatic. Specific determinating. Basta pinpoint mo na, yun, yung bagay na yun, okay. Consider that a specific determinate. Bakit mahalaga yan? Bakit mahalagang pinag-uusapan natin kung ang isang thing is a specific or generic? Kasi, depending on this particular designation of the thing, iba yung operation of law na mag-a-apply sa kanya. Which is, ito, sa follow-up ng discussion sa atin. So ito, nakalagay lang dito, specific thing and the generic thing distinguished. So, determinate thing is identified by its individuality. Kung saan, take note, yung specific determinate thing, it can never be substituted by the debtor. Pag sinabing ito yung bagay na kailangang ibigay ni debtor, Hindi niya pwedeng substitute yan without the consent of the creditor. Oo, hindi yan pwede. Kaya nga sasabi, di ba, may ibang application of law sila. Iba yung, 안녕하세요. Uy, 77. So, let's continue. Itong exam cell ko na to. Okay, sana ba yung specific determinate? So, gaya ng sabi ko, a determinating is identified by its individuality. Ibig sabihin, yun, pinpointed with particularity. Ngayon, si debtor, he cannot substitute such determinating with another kahit na
Sir, muted. Sir, muted.
Hello, mic test. Hello. Ba't bigla?
Okay na po, sir.
May mumu
Hi,
ata.
sir.
Baka matulad tayo dun sa Singaporean, no? 2 hours nagturo, tapos muted pala the whole time. So, yun. Gaya na sabi ko, a determinating is identified by its individuality na kung saan you can particularly designate it. You can particular pinpoint it kahit na nasa ibang group, kahit na nasa isang grupo siya. Oo. Like ito, grupo ng mga Poco M3 cellphone. Basta alam mo yung serial number niya, okay, you can pinpoint it na, yan yung cellphone with specific designation. Now, ito yung isa sa mga particularity pagdating sa sa specific determinating. Yung debtor, hindi niya pwedeng i-substitute yan. Humphrey, amin ka na daw. Si Humphrey sa may nag-chat dito. Okay, so saan tayo? So yun yung problema pagdating sa specific determinating. Si debtor, hindi niya pwede basta i-substitute. Kahit na same class yan, kahit na same nature, without the consent of the creditor. Pag niya pwede, pareho naman tong Poco M3 cellphone, tanggapin mo na lang. Pero sabi ni creditor, hindi. May sentimental value yung cellphone na yan. Yung cellphone na yun para sa akin. Hindi mo lang yung pwede basta-basta palitan. May mga ganong reasoning yun. So si debtor, hindi niya pwedeng pilitin si creditor na hindi. Pareho lang namang Poco M3 cellphone to eh. Hindi pwede ganon. Without the consent of the creditor. Now, pagdating sa generic thing, sa generic thing, since they are only identified by their species, si debtor, pwede niya yung palitan, pwede niya yung substitute as long as they are of the same class, as long as they are of the same kind. Like for example, sa rice, may jasmine rice si debtor, nasira, inamag or nabasa, di ba? Pero, since jasmine rice yan siya, and is not determined by its particularity, jasmine rice lang walang particular designation, pwede pa siyang kumuha ng ibang jasmine rice from other seller para yun ang ibenta niya doon sa kanyang buyer. Oo, pwede niyang i-substitute Yun yung kagandahan pagdating sa generic. Pwedeng may substitute. Always may kapalit. Ngayon, let's go to the ito naman. Isa sa mga another reason bakit it is very important to classify if the thing to be given is specific or generic. Kasi yung duties ni debtor in obligation to give nakadepende kung ano yung thing, specific ba or generic. Ito, duties of the debtor in obligation to give a determinate thing. Yung una, preserve the thing. Now, itong preserve the thing, in obligation to give, which is the real obligation, the obligor has the incidental duty to take care of the thing with due diligence of a good father of a family pending delivery. Now, as you can see, diligence of a good father of a family. Diligence of a good father of the family. Ang another tawag dyan is ordinary diligence. Bakit? Kasi may hierarchy of diligence tayo May hierarchy of diligence. Una, sa taas, extraordinary diligence. Second level, ordinary diligence, or dito sa atin ang tawag sa ordinary diligence is diligence of a good father of the family. the third level, the lowest level, is slight diligence. Slight diligence. Now, ano ba tong extraordinary diligence? Define lang natin. Extraordinary diligence, ang basically ano yan is meron kang extreme care or you are conducting with an extreme care and caution na when securing and preserving your own property. Extreme care and caution in securing and preserving, in conducting, paano mo i-manage yung property mo. Pagdating sa diligence sa pag-good father of the family or another name na ulitin natin is ordinary diligence, it basically equates to ordinary care or that diligence which an average or a reasonably prudent person exercise over his own property. Kita nyo ng difference. Extraordinary diligence, extreme caution. Yeah? Extreme caution, extreme care in managing his properties. Pagdating kay ordinary diligence, kay diligence sa pag-good father family, ordinary care lang. Ordinary care lang in managing his properties. Pagdating kay slight diligence, ito na yung type of diligence basically is what a careless person do in managing their property. Yan yung ginagawa ng isang careless person when they manage their own property. Now, ganito yan. When the law is silent, sabi ng obligations natin, yung type of care, yung type of preserving the thing sa isang obligation, ang dapat ini-apply dyan ni debtor is diligence sa pag-good father family. Yan yung automatic. Pero, if the law provides a higher level of care, yung batas ang susundin. Kung sabi ng batas, extraordinary diligence dapat. Extraordinary diligence dapat. For example, sa contract of common carrier. Bakit di na po ba papasok ang third person? What do you mean di na papasok ang third person? In what context? Miss Bade. Yung
So ano yun sir? Kanina sir sa yung sa intermediate na thing, yung sa generic, yung tinatanong ko kung doon na ba papasok yung third person.
What do you mean siya sa papasok? In what context?
Yung siya na yung gagawa ng obligation sir. Like, siya na yung magbibigay ng obligation sa expenses ng
later on ang pag-usapan sa generic kanina is since pwede ka pang may pagkunan, since considering na it's a generic thing, may pwede ka pang pagkunan para yun ang i-substitute mo dun sa nawala mong generic thing para yun yung ibigay mo sa buyer. Hindi pa tayo napupunta dun sa what if si debtor hindi niya nagawa yung obligation niya. Later pa yun. So, saan tayo?
Okay, sir.
Like for example, sa talking about extraordinary diligence sa contract of common carrier. Dito sa contract of common carrier, basta may franchise ka, like yung franchise sa jeep, franchise sa franchise sa tricycle, franchise sa bus. Pag ginan ka ng franchise, meaning you are now allowed to carry passengers. Kaya nga, contract of common carrier. Yan, common carrier. Ngayon, sabi ng batas, when it comes to common carrier, kailangan yung ine-exercise dyan is extraordinary diligence. Kaya nga ang tawag dyan is franchise Franchise, hindi right. Kasi ang franchise, it is a privilege granted to the applying person or applying entity para yung applying entity can have the privilege of carrying passengers. It is a privilege. It is not a right. Kaya nga, franchise ang tawag dyan. It is a privilege. It is a privilege. So, sabi ng batas, contract of common carrier, dapat extraordinary diligence ang ginagawa ng nagda-drive yan ng may-ari niyan. Bakit? Kasi you're ferrying passengers, human beings. So you need to take care of them. Buhay ang nakasalalay dyan. Buhay ang nakasalalay dyan. Since buhay ang nakasalalay dyan, sabi ng batas, extraordinary diligence po tayo. Oo. Ngayon, sir, ang sabi ng batas, extraordinary diligence. Pero yung kontrata ng party is, ordinary diligence lang. Pero yung sabi ng batas in that particular transaction, extraordinary diligence yung dapat gawin. Ayun ang masusunod, yung batas. Pag sinabi ng batas, extraordinary diligence, yun ang masusunod. Kahit sabihin pa, explicitly ng parties na, cool na kami sa ordinary diligence lang. Hindi, batas ang masusunod. Batas ang masusunod. Di ba sabi natin nung sa past discussion natin, a contract between persons has the binding force of law between them. Pero if the contract violates the law shall prevail. Di ba? Yun yung sabi natin. So, another standard of care, parties, factors to be considered. Now, sir, yung diligence po ba, meron tayong standard para dyan? Wala. Not necessarily na meron. Bakit? Kasi yung diligence na i-apply mo in certain transactions, nakadepende sa kung ano yung transaction na yun. Oo, it depends on the nature of the obligation. Oo, it depends. So kung sabihin na sa contract of common carrier, siyempre, driving yan eh. So magmaneho ka ng within the speed limit, hindi ka babara-bara, make sure na hindi ka inaantok habang nagdadrive, make sure na nasa condition ka. Exercise extraordinary diligence. Now, ito, nakalagay dito. What is the reason why the debtor's obligation in preserving that the debtor should preserve the thing? Basically, it is to protect the right of the creditor. Di ba? Sabi natin, debtor, obligor, they have the duty. Passive subject sila. Pagdating kay creditor, they are the active subject. They have the right. Sila yung may karapatan, sila yung may entitlement. So, sabi dito, kailangan talaga mag-exercise ng diligence ni debtor in order to preserve the right of the creditor. So, ito, another obligation or duty, ni debtor when it comes to specific determinate things, delivery of the fruits of the thing. Ito, fruits. Kahit sa lalabas niya, fruits. Which is 1164 pa. Another is the delivery of the accessions and accessories. 1166. Another is the delivery of the thing itself. Later on din yan. And answer for damages in case of non-fulfillment or breach. Ito na yung sinasabi kanina ni Miss Bade na kung saan papasok yung third persons. Diyan kay Article 1170 yan. Kasi papasok lang naman yung third persons kapag there are situations na si debtor hindi niya gagawin. May non-fulfillment on his part or baka hindi niya inayos yung trabaho niya pero later on pa yun. Ngayon, let's go to the duties of debtor. Kung makikita nyo dito, napakasimple ng duties ni debtor when it comes to delivery of generic thing. Because we're not talking about specific determinate thing here, we're only talking about generic thing. So to deliver a thing, unang duty niya, to deliver a thing which is of the quality intended by the parties taking into consideration the purpose of the obligation and other circumstances. So sabi dito, as long as same quality, as long as same nature, goods ka na. Kasi generic eh. And lastly, to be liable for damages in case of fraud and fraud, negligence, or delay in the performance of his obligation or contravention of tenor thereof. So ito, mahalaga rin to. Ang obligation natin sa board exam is around, sabi ko na ba to last time, ang obligation and contract sa board exam around 15 to 20 questions yan out of 100. Big part yan sa board exam. At least 10 yan siya. Ito. Klaro niyo sa Yung iba, definitions, objective type. Yung iba, situational. So, take note of fraud, negligence, or delay in the performance obligation or contravention of tenor. Ito yung mga klase ng ito yung mga klase ng topic na na-apply mo sa totoong buhay. So, let's go to Article 1164. The creditor has a right to the fruits of the thing from the time the obligation to deliver arises. However, he shall acquire no real right over it until the same has been delivered to him. Creditor, may karapatan. So, before we talk about Article 1164, let us talk about kung ano ba itong mga fruits na to. Prutas ba to, sir? Literal na prutas ba to? Hindi. When talking about law, there are different kinds of fruit. Meron tayong natural, meron tayong industrial, meron tayong civil fruits. Ngayon, natural fruits are the spontaneous products of the soil and the young and the other products of animal. Now sir, pagdating naman sa industrial are those produced by lands of any kind through cultivation or labor. Na sir, may mga certain instances na baka malitok kami kung natural ba yan or industrial. Ito lang titingnan nyo. If there is no human intervention, natural yan. Ngayon, if there is human intervention, industrial yan. Yun ang titingnan nyo. Tingnan nyo yung fruits. Kasi minsan nakakalito yun ng natural or industrial. Tingnan nyo. May human intervention ba? Industrial yan. Kung wala, natural yan. Ngayon, going to civil fruits, ito yung mga derived by virtue of juridical relations, like yung mga juridical contractual relations, yung utang ni Jericho kay Miss Bade, di ba? Ganon. Civil relations, hindi romantic ha. Baka aasa yung iba dyan. So yan, gaya ng rents of building, prices of leases of land, amounts of perpetual option annuities, yun. Based on the juridical relation. Ngayon, ito yung mahalaga pagdating sa 1164 ha. As long as the time of the delivery of the tawag dito? As long as si debtor wala siyang obligation to deliver, generally, walang karapatan si creditor over the thing. Wala siyang karapatan over the thing. As long as walang obligation si debtor to deliver. Na sir, sabi mo generally, so may exception yan? Oo, may exception yan. Pero, discuss ko na ba ngayon? Yung exception yan, basically, in layman's term, or simplehan yung term na yun, kahit na walang karapatan si creditor over the thing, meron pa rin siyang karapatan, yun? To make sure na yung thing na yon will be properly delivered from him. To him pala. To make sure that the thing will be properly delivered to him. Anong mga instances yan, sir? Like for example, ganito. Si debtor may binebentang cellphone. So ngayon, nag-usap na sila ni creditor na on January 15, i-deliver ko na sa itong cellphone. Sabi ni debtor. O sabi ni creditor, sure. Thank you, sige, meet tayo January 15. Ngayon, etong si creditor, nung nag-stock ng Facebook account ni debtor, nakita niya na yung same unit of cellphone, we're talking about specific thing here, yung same unit of cellphone, pinost niya sa Facebook Marketplace, the same unit of cellphone. Paano yan? Ibibenta ni debtor sa iba yung yung cellphone na napag-usapan nilang i-deliver niya sa kay creditor. So in that cases, pwede nang mag-file ng petition. Oo. At first, sabihan muna ni creditor si debtor na, yung nakita ko sa Facebook Marketplace na binibenta mo yung same unit of cellphone na dapat i-deliver mo sa akin sa January 15. Sabi ni debtor, hindi, bahala ka dyan. May nag-offer sa akin na mas mataas na price. Sabi ni creditor, hindi, may pinag-usapan tayo na in that case, pwede ka nang pumunta sa korte kapatid. File ka ng petition. Oo. Na i-prohibit yung ginagawang kalokohan ni debtor. Oo, yun yung mga certain instances na ginagawa ng isang creditor to make sure na ma-protect niya yung rights niya. Kahit na hindi pa dumarating yung date of delivery. Kahit hindi pa dumarating yung date o yung time na kailangan ng i-deliver ni debtor yung thing sa kanya. So yun, napa-advance tayo ng topic pero ganun yun. Those are the certain instances na kahit pa hindi pa dumating yung obligation to deliver, the creditor has the right to protect his interests. So sana tayo. So ngayon, the creditor is entitled to the fruits of the thing to be delivered from the time the obligation to make delivery arises. So the intention of the law is to protect the interest of the obligee or the creditor should the obligor debtor commit delay purposely or otherwise in the fulfillment of his obligation. Ngayon, kailan ba nagkakaroon ng obligation to deliver the fruits? Una, At the perfection of the contract. So, at the moment na perfect yung contract, okay, obligation to deliver na. So, meron ng right si debtor over the fruits. Sir, anong right yan? Right to demand the delivery. Right to demand the delivery. Yun yung pinag-usapan dito. The right to demand the delivery. Pag dumating ng January 15, o sige sabi, independent example, pag dumating ng January 15, ngayon, pwede na mag-demand si creditor, oy debtor, deliver mo na sa akin, meet up tayo sa KCC. Okay, goods. Ngayon, another instance kung saan the obligation to delivery arise is pagdating ng suspensive condition or suspensive period. Wala sir, di ba later on pa yan? Later on pa yan yung mga yung mga suspensive, yung pecuniary, later on pa yan sila. Basta basically ang suspensive and resolutory. Pagdating sa suspensive condition, suspensive period, basically meaning lang yan, sa suspensive condition, upon the happening of the condition, the obligation to deliver arises. So, let's say, ang condition is manalo ang Lakers. Di ba? Manalo ang Lakers sa finals. So, pag nanalo ang Lakers sa finals, that is the obligation to deliver the thing arises. Meaning, pwede nang i-demand ni creditor kay debtor na, oy, nanalo yung Lakers kagabi. Deliver mo na sa akin ang cellphone. Okay, goods. Ma-demand niya na. Yung suspensive period, ito naman, talking about time, pagdating ng let's say, yung example natin, pagdating ng January 15, upon the arrival of the period, the obligation to deliver arise. So, pagdating ng January 15, yun, the obligation to deliver arises. Pag the obligation to deliver arises, dumating na, then the creditor has the right to demand. Ito na ang contract to sale, ito na obligation to give. Ngayon, napag-usapan natin yung personal obligation, napag-usapan natin yung real obligation. Yeah. Ngayon, mahalaga tong real right pati personal right kasi hindi lang dito sa loan obligations and contracts yan makikita. In other subjects nyo rin dito sa accountancy. Sa taxation, meron yan. Kung ano yung personal rights mo, anong real rights. Other law subjects, meron din yan. Basta RFBT and taxation, makikita nyo yung personal right and real right. So, si personal right, basically, this is the right or power of the person, the creditor, the active subject, to demand from another, the debtor, obligor, the passive subject. Yeah? Kasi, active subject, the right to demand kay creditor. As a definite passive subject, the fulfillment of the latter's obligation to give, to do, or not to do. Pagdating naman sa real right, it is basically the right or interest of a person over a specific thing. Gaya ng ownership, possession, mortgage, without a definite passive subject against whom the right may be personally enforced. So, paano sila? Basically, si personal right, meron tayong definite. Ibig sabihin, alam natin, mapinpoint natin kung sino yung passive subject, sino yung active subject, kung sino yung obligor, kung sino yung obligee. Pero pagdating kay real right, mapinpoint lang natin kung sino yung active subject. Pero hindi natin mapinpoint kasi walang yung passive subject kasi walang definite passive subject. Bakit? Kasi pagdating sa real right, it is a right that is directed against the whole world. Kasi sinasabi mo dito na akin to. Ina-announce mo yan sa lahat, real right. Akin to. It is a right directed against the whole world. Akin tong lupang to. Akin tong cellphone na to. Yun yung pinepertain. Yun yung basically, in layman's term, the basic definition of a real right. You're saying na this is mine. This is a right directed against the whole world. Pagdating sa personal right, it is only binding. It is only enforceable against a particular person. It is only between the two of you. It is only between those definite passive subjects and you, the active subject. But when we're talking about the real right, it is a right directed against the whole world. Kaya sabi dyan, walang definite passive subject because it is a right directed against the whole world. Pinoproclaim mo, akin itong lupang to. Hindi mo sinasabi, hindi. Whole world yan. So yun yung basically simple definition or simple difference between a real right and a personal right. So take note of that. Huwag niyo yan kakalimutan. Ilang beses yan matatanong sa inyo in your accountancy life. So ownership and other real rights over a property is acquired, transmitted as a consequence of certain contracts by tradition, meaning yan, or delivery. So pinag-usapan ng delivery dito. So ito idagdag ko ng notes na to. Take note of these types of delivery. Kasi basically itong types of delivery na sa sales to na pag-uusapan pero sa sales yan na pag-uusapan, pero bigay ko na ngayon sa inyo bigay ko na ngayon sa inyo. Types of delivery, meron tayong dalawa. Actually, ma-search lang man to sa internet. Yung actual and yung constructive. Sa actual, meron tayong actual delivery. Na-receive mo talaga yung bagay. Actual delivery. Merong actual transfer of ownership. Actual transfer dating. Pagdating sa constructive, from the word itself, it is only abstract, it is only constructive. There is no physical transfer. So, paano nagkakaroon ng delivery niyan, sir? Depende sa situation. May tinatawag tayong tradition simbolika. Don't worry, kahit ninyo isulat to, nasa internet naman to sila. Nandito lang kasi sa lobo ko kasi it is an additional note. Sinulat ko lang dito. Tradition simbolika, ibig sabihin symbolic transfer. Ganun lang yan. Sinisimplihan natin yung term nila kasi mas naintindihan natin kapag sinisimplihan natin. Meron tayong tradition simbolika. Kung saan? Di ba? Meron tayong tinatawag na titulo ng lupa. Diba? Title of lands. Alangan naman, itatransfer mo yung lupa papunta sa kabila. Hindi na. Impossible yun. Di ba? Impossible. Mahirap yun gawin. So, ang gagawin na lang, title na lang, yung titulo na ng lupa, i-transfer mo, punta ka sa registry of deeds, lagyan ng annotation, sinong new owner, yun. Tradition simbolika, symbolic transfer. Title of land, okay. Kung sino yung nasa annotated transfer of title of land, yun na yung may-ari, hindi na kailangan i-transfer pa yung lupa. Na literal na transfer. Yung second is yung traditional longa manu meaning long hand, kaya longa manu. Dito, ang basically nangyayari is you're pointing the object. Yan sayo na yan, ganun. Yang kotse na yan, sayo na yan. You're just pointing. Yung ballpen na nandun, yung ballpen na nandun, sayo na yan. Kaya nga longa manu. Long hand, you're just pointing the object. Pagdating sa tradition brevi manu, short hand data tawag yan if I remember correct kasi longa manu. So brevi manu, you are already there. You already own the you are already there kung saan yung bagay na yun. And lastly, tradition constitutum possessorium, ito medyo complicated to. Pero meron itong transaction sa accounting pagdating nyo sa leases. So, leases is intermediate accounting part 2. Basta search nyo, sales, lease, back. Sales, lease, back. Yan ang good example ng tradition constitution possessorium. Basically, kung isimplihan natin, you own it, you sold it, but you want to rent it. So, paano yun? Example ako, may bahay ako. Ngayon, itong kaibigan ko, usap-usap kami, nagkaroon kami ng agreement. Ibibenta ko tong bahay ko sa kanya. So, yung transfer of title, yung kung sino na yung may-ari ng bahay, based on the title of ownership, nasa kaibigan ko, nagbentahan kami. Pero, isa sa mga napag-usapan namin is, kahit na yung pagmamay-ari, yung ownership ng bahay, nasa kanya na, magre-rent na ako. I-rent ko na yung bahay. So, sales, then lease back. Sales, binenta ko sa kaibigan ko, pero i-rent ko yung bahay. So, nakatira pa rin ako dito. Sales, lease back. Pagdating nyo sa leases nyo sa intermediate accounting part 2, kasama yan. Sales, lease back ang tawag sa transaction na yun. So, yan. Additional note yan. Kasi usually yung types of delivery, binibigay yan sa sales pa. Kasi dito sa book ko, walang types of delivery. Kaya sinulat ko dito nung undergrad ako. So, sana tayo dito? Uy, saan yung page na yun? Saan yun? Sa personal real right, ownership accord to delivery. Now, let's go to Let's go to Article 1165. So, sa Article 1165 provides that when what is to be delivered is a determinate thing, the creditor, in addition to the right granted by him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing or to two or more persons who do not have the same interest, he shall be responsible for the fortuitous event until he has effected the delivery. Ito. So, Article 1165 talks about the remedies of creditor in real obligation. Yan yung sa Saan yun? Okay, goods. Wait lang, ayusin ko mo po. So, remedies of creditor in a real obligation. So, there are certain instances, ito lang yung sinasabi ni tinatanong ni Miss Bade kanina. Yung basically talks about the non-compliance. What if na hindi nag-comply si debtor, si obligor sa kanyang obligation when it comes to delivery? When it comes to the obligation to give. So ano nung gagawin ni creditor? May remedies siya. May pwede siyang gawin. May pang-backup siya kumbaga. May backup plan siya. Provided yan ng batas eh. So, in specific real obligation, meaning it is an obligation to deliver a determinate thing, kaya specific real obligation, si creditor may exercise the following remedies or rights in case the debtor fails to comply with this obligation. Na kung makikita niyo yung list na to, nakalagay yung word na or. Diba? A, blah, 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 or B, blah, 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 or C, blah, 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 blah. Anong meaning yan? Meaning yan, exclusive lang. Isa lang ang pwede mong piliin. Isa lang ang pwede mong piliin. Hindi sila pwedeng mutual. Hindi pwedeng, gusto ko piliin yung A and B. Combine ko sila. Hindi ganun. Isa lang yung pwede mong piliin depending on the circumstances available. Dito, una, demand sa letter A. Demand specific. Pag hindi nakakomply si debtor, anong remedies niya, creditor? Una, demand specific performance or fulfillment. If it is still possible, of the obligation with the right to indemnity for damages. So nakita nyo, demand specific performance of the obligation to give. Take note to give yan. Kasi pagdating sa to do, iba na ang usapan. So take note, demand specific performance or fulfillment with right to damages. With right to damages. So bakit? Kasi may non-compliance na eh. May non-fulfillment na. So pwede ka na mag-demand ng damages kasi may civil liability na dyan eh. Hindi ka nag-comply. Yung second na pwede mong gawin, demand rescission or cancellation. In certain cases available, the obligation and with right to damages. Ano tong rescission, sir? Basically, on the word, cancellation, rescission. I-cancel nyo na yung contract. Ika-cancel nyo na yung contract. With right to damages. Ngayon, kapag the circumstances, when the facts of the case, ang sabi, parang hindi na available yung specific performance, hindi na available yung rescission, then, dun ka na sa third remedy. Demand payment for damages only where it is the only feasible remedy. Yun na lang yung pwede mong gawin. Mag-demand ka na lang ng damages. In an obligation to deliver, the very thing itself must be delivered. Consequently, on the debtor can comply the obligation with the creditor can compel. Take note, pagdating sa obligation, specific determinating, it is only the debtor, it is only the obligor that can deliver the thing. Siya lang. Kasi nga specific eh. Particularity yan. Hindi niya pwede sa ibang tao. It should be made clear, however, that the law does not mean that used for violence. So sabi dito, Huwag kang gumamit ng dahas, pumunta ka sa korte. Ngayon, pagdating sa generic real obligation, generic na, indeterminate na. Dito, yung sabi niya ni Miss Bade, pwede nang pumasok si third person. Pwede nang pumasok si third person. On the other hand, can be performed by a third person since the object is expressed only according to its family or genus. So, hindi necessary na i-compel talaga, na pilitin talaga ni creditor, si debtor, na mag-comply. Kasi dito, in this case, in case of generic, pwedeng yung ibang third persons, pwedeng outside parties yung mag-comply. Pwede ganun. So, hindi necessary na pilitin talaga ni creditor si debtor. Pwede siyang mag-demand. Hindi natin tinatanggal yung karapatan na yun. Pwede siyang mag-demand. Pero, it does not necessarily mean na yun lang yung pwede niyang gawin. Pwede niya ring punta sa other parties, sabi niya, yung seller ko dito, hindi ako dineliver ng sinandoming na bigas. Ikaw, may sinandoming ka ba dyan? Sabi ni Deto ng isang outside party, yes sir, available. Yun. Sige nga, bili nga 50 sacks dyan. Loko-loko kasi yung seller ko. Yun. Pwede yun. Because we're talking about a generic thing. But take note, kapag may damages na na-incur, pwede. Kasama yon sa pwedeng habulin ni creditor kay debtor. Anong example yan, sir? Like for example, dito example. Yung usapan nyo ni original seller mo, 50,000 yung magagastos yung para sa bigas. Pero, hindi niya na nasatisfy yung delivery. So ngayon, since kailangan mo ng sinandoming, pumunta ka sa ibang seller. Doon ka bumili ka. So pagdating sa ibang seller, yung presyo sa kanila, 55,000. Ala na, nasobrahan ka pa sa bayad ng 5,000. Paano yan? Ngayon, since that is considered to be damages. Kasi kung hindi, dahil sa non-compliance ni original seller mo, hindi ka sana mapapagastos ng extra 5,000. So yung 5,000 damages na yun, pwede mong habulin kay original seller mo. Kasi kasalanan niya napasobra ka ng bayad. Kasalanan niya. Ganon kasimple. Ngayon, when debtor delays or has promised delivery to separate creditors, ito. Pagdating, example, seller ka, tapos nag-promise ka ng delivery sa 2 tao. Automatic ba may kasalanan ka? Automatic ba bad faith ka? Hindi. Depende sa bagay. Kaya nga sabi natin, importante na ma-properly classify kung specific yan o determinate. Kapag yung pre-promise mo sa 2 tao is specific determinating, bad faith ka, may kasalanan ka. Pero pag yung pre-promise mo is a generic lang, indeterminate lang, goods ka pa rin. Wala kang kasalanan. So, paano yung application yan, sir? Later on. So, let's go to, 1166, pagdating ng page 50, rest tayo. Pagdating ng, okay, naihi na rin ako later on. Pagdating, okay. So, 1166, the obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. So yan, we're talking about accessions and accessories. So ano tong accessions? Ano tong accessories? Accessions are the fruits of the thing or additions to or improvements upon the thing or principle. So sir, importante ba na maklasify namin yun, accession or accessories? Hindi naman. Unlike sa fruits, pagdating sa accession and accessories, always yan sila ginugrupo. Hindi nyo na kailangang i-separate yan sila. Always yan. Accessions, accessories. Pagdating sa mga exam, di yan sila sineseparate. Goods lang yan sila. Goods na. Always yan sila together. Accessions, the fruits of the thing, or additions to or improvements upon the thing. For example, so accessions is the, kung saan, improvements sa thing which is considered a principal. Example, house or a trees on a land, rents of a building, air conditioner in a car, profits or dividends, accruing from shares. So basically, accessions, these are produced, these are incorporated, these are attached to the thing, the principal thing. These are produced, these are incorporated, meaning dinikit mo, sinama mo, in-include mo. These are attached to the principal thing. Pagdating sa accessories, are things joined or included with the principal thing for the latter's embellishment, better use, or completion. So, anong diferensya nila, sir? Kung makikita nyo, itong accessions, itong accessions, wait lang uhaw tayo. Kung makikita nyo, accessions, ano yun? Nawala tuloy tayo. Accessories, example yan, key of houses, frame of pictures, bracelets of a watch, machinery, bow of a violin. Note that while accessions are not necessary to the principal thing, the accessory and the principal thing must go together. Both exist only in relation to the principal. Accession is also used in the sense of right of fruits. So, gaya na sabi ko, hindi sila importante ma-distinguish. Kasi minsan, minsan, natawag dito, na may mental block tayo. Hindi sila importante na ma-distinguish accessions and accessories because, ulitin ko, they always go together. They always go together. So, ang general rule, gaya na sabi ng provisions ng 1166, pagdating sa kahit hindi mentioned sa contract, kahit hindi mentioned sa agreement, automatic, yung accessions, yung accessories, isasama mo yan sila sa principal thing. Yun yung general rule. So, sir, may exception? Yes, may exception. Anong exception? When the stipulations of the contract explicitly said na excluded sila, di hindi sila kasama. Yun lang yun. The general rule, kahit hindi mentioned sa contract, sa usapan nila, isasama mo. Exception, kapag explicitly sinabi na hindi isama, exclude mo. Oo, kasi, bakit sir? Bakit strict yan pagdating sa ganyan? Because, yung accessions, yung accessories, yan yung nagpapaginhawa, yun yung nagpapadali ng buhay mo in using the property, in using the principal thing. So sabi ng batas, kahit na nakalimutan ng parties na explicitly sabihin na isama yan, automatic kasama yan because pampagaan ng buhay, pampadali ng buhay sa paggamit ng principal thing. Now let's go to Article 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. Ito na. The same shall be executed at his cost. The same rule shall be observed if he does it in contravention of the tenor obligation. Furthermore, it may be decreed that what has been poorly done be undone. So ito na. Ito na yung mga certain situations. Tawag dito. Na kung saan si debtor nagpasaway sa kanyang obligation to do. Pinag-usapan dito, obligation to do. Kaya kita nyo, if a person obliged to do something fails to do it. So, we're talking about positive personal obligation, the obligation to do, obligasyon mong may gawin. So, in that cases, when the debtor fails to perform his obligation, anong mga mangyayari? Anong situations yan? I mean, una, the debtor fails to perform an obligation to do. Meaning, kinontrata ka para kumanta pero hindi ka pumunta. Hindi mo ginawa. So yan, the debtor fails to perform an obligation to do. Second, the debtor performs an obligation to do but contrary to the terms thereof. Kinontrata ka para mag-rap pero nagbalad ka. Kinontrata ka para mag-rap sa concert pero balad ang ginawa mo. O yan. You perform the obligation, kumanta ka nga. Pero, you did it contrary to the terms. Rap ang pinapagawa sa'yo, nagbalad ka. Third, the debtor performs an obligation to do, pero in a poor manner. Akala nila magaling kang kumanta sa kontrata. Pero, pagdating sa concert, pagdating sa performance, yung kinontrata ka nila, o pagdating sa wedding, yun pala, putyo-putyo boses mo. You did perform the obligation, but you did it poorly. So yan, obligation to do. Ngayon, pag gano'n yung nangyari, anong remedies ni creditor? Kasi kawawa naman yan eh. Na-dengoy siya. na loko-loko yung creditor, yung debtor, yung obligor, hindi niya nagawa ng maayos yung kanyang obligation. So ano mga remedies noon? Una, if the debtor fails to comply with his obligation to do, the creditor has the right. Una, ito, kung makita niyo ito, end. Ibig sabihin, pwedeng ipagsabay ito. A, blah, 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 and B, blah, 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 blah. Ibig sabihin, pwedeng ipagsabay. Una, to have the obligation performed by himself or by another unless personal considerations involved of the debtor at the debtor's expense and to recover damages. Ito na yung tricky part sinasabi natin. 'Di ba? Pagdating sa obligation to give, tag dito? Di ba pagdating sa obligation to give, kahit na specific yan or generic, ang sabi natin, pwedeng i-compel, pwedeng mag-demand si creditor kay debtor. Pwede. Demand. Demand. Pagdating sa positive personal obligation, pagdating sa obligation to do, medyo, tayo dyan medyo aatras tayo ng konti. Bakit? Ganito yan. Si creditor, when it comes to specific performance, he cannot demand the debtor. He can only ask, uy, bakit gawin mo naman to He can only ask, but he cannot demand. Why? Because it will go against involuntary servitude. Sabi ng Constitution natin, explicit yan sinabi, bawal ang involuntary servitude. Bakit? Because that will amount to slavery. That is amounting to slavery. Kaya sabi ng Constitution natin, bawal ang involuntary servitude. So hindi mo siyang pwede pilitin na gawin mo to. Magkumanta ka. I demand you to sing. I compel you. You cannot do that. That is involuntary servitude. You can only ask na, uy, sana naman, ituloy, kumanta ka naman. Hindi pwede. Yun, ask lang, pwede. Demand, yun. Hindi pwede. Involuntary servitude na yan. Ngayon, gaya na sabi dito, to have the obligation performed by himself. Like for example, magayos ng kotse. Yun, labor yun. Obligation to do yun. Di ba? So kapag yung mekaniko na kinontrata mo, hindi ginawa yung pag-ayos ng kotse, so ikaw, alam mo naman paano magayos, then you can do it by yourself. Or, pumunta ka sa ibang mekaniko, yun na lang ikontrata mo para yun sila ang gumawa. Para sila yung gumawa. Or by another. So, third person yan, outside parties. At the debtor's expense. Ngayon, balik tayo sa example natin na pagkanta. Like for example, sabihin natin, sino bang, for example, sabi natin si Sarah Geronimo. Siya yung explicitly na gusto pakantahin, kinontrata para kumanta. Kaso hindi siya makakanta. Hindi niya ginawa yung kanyang obligation si Sarah Geronimo. So ngayon, medyo tricky situation mo. You can ask Sarah to sing. Pero pag sabi ni Sarah ayaw niya, hindi mo pwede pilitin. Ngayon, can you perform the obligation by yourself? Can you ask another person to perform the obligation? Medyo hindi. Hindi. Kasi, yung nangyari dito is personal consideration was involved. Gusto ng tao, si Sarah yung kumanta. Hindi mo pwede pasok sarili mo para ikaw ang kumanta. Hindi mo pwede pasok yung ibang artist para yun silang kumanta. Kasi, yung kontrata talaga, si Sarah yung kakanta. So, in that case, personal considerations was involved. Hindi essence of Sarah Geronimo. Yun. So in that case, wala ka na magagawa. In that case, wala ka na magagawa. Recovered. Hindi mo na magagawa yung first part, recover damages na lang. Kasi hindi mo pwede pilitin si Sarah And then si Sarah, under the essence of personal considerations, recovery of damages na lang. Mag-file ka ng petition for damages against Sarah Geronimo for not complying with their obligation. Ganon, no? Di ba? nagkaroon ng trickiness, no? Nag-iba yung dynamics kasi obligation to do na to. Nag-iba na siya as compared to obligation to give. Ngayon, eto, sa first part, non-compliance. Sa second part, there's compliance. But, the obligation was done in contravention of the terms of the same or is poorly done. So, it may be ordered by the court upon complaint that it be undone if it is still possible to undo what was done. Like, example, nasira yung makina mo. Oh, dahil kasi it was poorly, mas nasira yung makina mo because it was poorly fixed by the mekaniko. So, ano mangyari dyan? Pwede nyo pang ayusin, i-undan kung ano nasira, ayun, etc. Ganun yung mangyayari. So, let's go to Article 1168. After ng Article 1168, rest muna tayo. Kasi yung iba sa inyo, inantok na, hilamos rin ako, nahihi rin ako eh. So, Article 1168 provides that when the obligation consists in not doing, and negative personal obligation na to, obligation not to do. So, when the obligation consists in not doing and the obligor does what has been forbidden him, it shall also be undone at his expense. It shall also be undone at his expense. So, ito na yung obligation o negative personal obligation. Dito, walang specific performance kasi ang sabi lang, wag mo tong gawin. Sabi mo kapatid mo, wag mo kainin yung iniwan kong cake sa ref. Yun. Negative personal obligation because that cake is yours. So pagdating sa sa 1168, pagdating sa negative personal obligation, ang gagawin lang dito, ang remedy lang ni obligee is undoing of the forbidden thing plus damages. Undoing lang, undone lang. Example, pinagbawalan kang magdikit ng poster sa dingding. Ginawa mo pa rin, pasaway ka. So ang mangyari lang, i-undan mo, tanggalin mo yung poster. Now, if there are any damages damages sa dingding, pay ka rin ng damages. Ngayon, pag hindi na possible ma-undo, either physically or legally man, then action for damages na lang. Pag hindi na ma-undo. So with that, rest muna tayo. Nahi na rin ako. 10 minutes break. 10 minutes break. Ganyan talaga sa mga law subjects. First hour, okay pa yan. Pag lumampas na ng first hour, ayan, dyan na nakakaantok. Promise. Kahit sa law school, ganyan. Lahat. Basta law subject, first hour, okay pa yan ng mga students. Lumampas na ng first hour, dyan na. Kita mo na yung mga, yung iba, pinipigil pa. Kaya kailangan ng breaks talaga yan. Kaya nga essential talaga ang recitation. Bakit? Kapag may recitation, tapos random, alert yan ng students the whole period. Alert yan the whole period. Di yan matutulog. Nakatingin lang yan, kinakabahan. Kasi baka matawag yung pangalan nila, tapos baka antok-antok sila. Pagalitan sila ng abogado, GG yan. Kaya essential yan ang recitations. So with that, ano yun? Okay, with that, let's go to Article 1169. Nice. So, Article 1169, those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demand from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist in the following circumstances: when the obligation or the law expressly so declares, or when the nature of the obligation and the circumstances of obligation appears that the designation of time when a thing is to be delivered, etc. Mahaba sila. Another, when demand would be useless. And the last paragraph talks about reciprocal obligation. Now, itong Article 1169, nice. Pag-uusapan na dito yung delay. Delay. Now, sabi dito, ano meaning ng delay? May may iba yan pag using in ordinary parlance and when using it under the system of law. So, sabi dito, the word delay as used in the law is not to be understood according to its meaning in a common parlance. A distinction therefore should be made between ordinary delay and legal delay. Kung saan ang tawag usually is default or mora in the performance of an obligation. So sa ordinary delay, there is merely failure to perform an obligation on time. Yun lang. Okay. Turn correct. You can may napindot to. Yun lang. Failure to perform an obligation on time. Yun lang, ordinary delay. Pagdating sa legal delay, default or mora, tandaan niyo mga other names yan, default or mora, the failure to perform an obligation on time, which failure constitutes a breach of the obligation. Ano meaning yan? Generally, kapag may demand, eto na, tandaan nyo itong phrase na to. General rule, no demand, no delay. No demand, no delay. That is the general rule. No demand, no delay. Oh, sabi natin general rule, so may exceptions yan pero later on na. No demand, no delay. Yan ang isa sa mga phrase na kailangan tandaan nyo. No demand, no delay. So what are the types of delay? So mora solvendi, delay on the part of the debtor. Mora accipiendi, the one who's accepting, delay on the part of the creditor sa pag-accept ng performance ng obligation, and compensation more, delay on both parties in a reciprocal obligation. Reciprocal obligation, ibig sabihin, yung isang party, obligor and debtor siya, yung isang party, obligor and debtor siya, so may obligation sila sa isa't isa, and may duties sila sa isa't isa, and may rights sila sa isa't isa. So, reciprocal. From the word itself, parang bilateral yan. So, take note, nagkakaroon lang ng delay. Diba? Tatlong obligations tayo basically meron. Tatlong obligation. Let's say, dalawa. Real obligation to give, yan, may delay dyan. Pagdating sa personal obligation, depende. If it is a positive personal obligation, then may delay yan. Pagdating sa negative personal obligation, walang delay dyan. Kasi negative personal, wala kang gagawin. Oo, obligation not to do yan. Paano ka magkakadelay dyan, di ba? Wala ka nang gagawin at the first place, so wala ka nang delay at the first place. So, what are the requisites para naipit. So, anong requisites yan? Anong conditions ang kailangan mo para makonsider mo para makonsider na delay, para makonsider na default, para makonsider as mora yung nangyari kay debtor? Tatlo tayo meron dyan. Oo, tatlo. Una, the failure of the debtor to perform his positive obligation on the date agreed upon. Ibig sabihin, hindi niya nagawa yung obligation to give, hindi niya nagawa yung obligation to do kung kailan niya kailangan gawin. Next is the demand. Ito, gaya na sabi natin, no demand, general rule, no demand, no delay. So, yung second requisites, demand, not mere reminder or notice ha. Hindi lang pwede, yung obligation mo. Hindi, not mere reminder or notice, hindi yan acceptable. Demand made by the creditor upon the debtor to comply with this obligation, which demand may be either judicial, ibig sabihin, dadaan ka sa korte, extrajudicial, meaning outside of court yan. O usually, yan yung kukuha ka ng abogado para yung abogado maggawa ng letter. So may letterhead yan ng law firm. Mas nakakatakot yun, letterhead ng law firm, abogado nagpadala ng demand sa'yo, demand letter. Oh, yan, extrajudicial yan. Judicial, dadaan ka sa korte, magpa-file ka ng petition. Extrajudicial, outside of court ang meaning yan. So yan sabi natin no general rule, pag walang demand galing kay creditor, hindi mo makakonsider na delay yan. Bakit? Let's say, sabi ng contract, on January 15, i-deliver ni debtor kay creditor yung inutang niya na 15,000. Dumating ang January 15, hindi nabigay or hindi na-deliver. Pakisabi kay Alair, pakisabi kay Alair, Wimso account ang gamitin. So, yun sabi natin, pag yun na, hindi na-deliver by January 15 yung inutang ni debtor na 15,000. Automatic ba delay yun? Automatic ba legal delay yun? Automatic bang default or mora yun? Hindi. You can consider that as an ordinary delay, but you cannot consider that as a legal delay. Bakit? Kasi on January 15, yes, hindi na-comply. Pero wala pang demand na ginawa si creditor. So pag nag-demand si creditor na, padala sa letterhead galing sa attorney mismo, demand letter. O yun, doon na mag-start ang delay. Doon na mag-start ang legal delay. So ngayon, may legal delay na. Ngayon, may demand na, So, ngayon, si debtor, he fails to comply with such demand. So, when the debtor fails to comply with such demand, yun, may delay na tayo. So, failure to comply, then may demand, not only mere reminder or notice, but kailangan yung maayos talaga, whether that's judicially, dadaan ka sa korte, or extrajudicially, outside of court. Demand, matanggap niya yung demand. Okay, pero hindi pa rin siya nag-comply. Legal delay na yan. Legal delay na yan, and that legal delay, may mga consequences yan, of course. So, ayusin natin tong So, saan tayo dito? Nag-busy ang page. May nag-chat. Sir, yung summon. Now, yung summon, that is, wala pa man kami sa procedural law. But basically, summon, parang invitation to court lang yan. Yung subpoena, yun yung required kang pumunta. Oo. Yung summon, tanong nyo, sa korte yan, invitation lang yan Yung usually sa korte yan nangyayari. Subpoena, yun yung required. So, ang tanong nyo, sir, yung summon, extrajudicial yung summon, sir? Depende. Wala pa kasi kami sa sa procedural law, sa rules law. Tawag doon? Sa remedial law when it comes to the proceedings in court. Second year pa lang ako, bes. Mga third year pa yan ituturo sa amin. Second year pa lang ako this second sem. Pero yun, yung summons, basically, invitation yan, subpoena yung required. Parang ganun yan siya. So ngayon, saan tayo? Failure to, requisites. Now, ano mga effects ng delay? So, listed naman yan dito Sana yun dito? Ito, examples. So, effects ng delay. Pag mora solvendi, meaning delay on the part of the debtor is guilty of breach of breach or violation ng provisions ng kanilang obligation. So, liable siya to the creditor for the interest or damages. Ngayon, itong interest na to, yung counting, nakadepende. May example kayo nakita dyan. Pag meron kang extrajudicial demand, doon mag-start yung interest. Counting of interest. Kasi example, yung utang mo 1,000 pesos. Tapos hindi nabayaran. So yung counting ng interest, mag-start yan sa Yung importante kasi ng interest is, wala pa kayo financial Basta ganito yan ang interest. Ganito yan ng interest. Example, may utang na pera sa'yo. On December 1, dapat babayaran na. Kaso hindi nabayaran. So yun, as time passes by, ang interpretation dyan, sayang. Yung 1,000 pesos sana, nagamit ko sana kung nabigay lang sa akin nung December 1. Sayang, nagamit ko sana, na-utilize ko sana yung 1,000 pesos na yun. Kaso ang problema, hindi ko man natanggap. So, ang tingin dyan, may loss on your part. Kasi sayang hindi mo na-utilize agad yung 1,000 kung na-deliver lang agad sana yun sa'yo. Nabigay lang agad sana sa'yo, na-utilize mo sana. So, to compensate that loss, may tinatawag tayong interest. Yeah? So, December 1, hindi nabigay sa'yo. So, until hindi nababayaran yung 1,000 na yun, yung interest will continue to accrue. Magka-count pa rin yan. Until sa mabigay yung 1,000 sa'yo, and kasama niyan yung interest na na-accrue dahil sa delay. So, kung example, 3 months bago nabigay sa yung 1,000 peso. Eh di 3 months rin yung counting ng interest. Bakit? To compensate the loss on your part. Kasi, gaya na sabi ko, kung maaga lang, kung sakto lang nabigay sa agad yung 1,000 peso, eh na-utilize mo sana agad, nagamit mo sana agad. Eh kaso hindi, di ba? Natagalan sa pagbigay sa'yo. So in order to compensate that non-utilization, kasi kasayang nagamit mo sana agad, may tinatawag tayong interest. Yun yung punto ng importansya ng isang interest. Yung interest payments pag nakita kayong for interest diyan, maraming interest kasi words yun sa yun yung pinupunto doon. Nagamit sana kung na-deliver agad. Kaso hindi. So in order to compensate, to indemnify for such loss of non-utilization, payment of interest. Ito is following effects ng delay ni debtor, guilty of breach or violation of obligation, liable to the creditor for the interest. For the interest. Kasi hindi nabigay sa kanya agad na-delay So hindi niya nagamit agad, sayang. Or damages in other obligations, in the absence of extrajudicial demand, the interest shall commence from the filing of the complaint. Sabi natin, kung may extrajudicial demand, yung counting ng interest, mag-start sa date na yon. Pag wala, kung kailan nag-file ng judicial complaint. Liable for fortuitous event. Ito, mahalaga to. Itong fortuitous event pagdating dito. Nagiging liable lang siya. Kasi ito, paano ko ba to? Later on kasi pag-usapan natin yung fortuitous delay. Basically, yung fortuitous delay, kapag nangyari yan sa'yo, excuse ka na sa iyong obligation. Ma-excuse ka sa obligation mo. However, kapag nauna yung legal delay kaysa sa happening ng fortuitous event, Diyos ko, wala kang takas, kapatid. Kapag nauna yung legal delay sa fortuitous event, wala kang takas. Wala kang takas. Yun lang meaning niya dito sa letter C. Ngayon, but take note ulit, fortuitous event only affects specific determinating. Di ba? Sinasabi natin, mahalaga na ma-determine nyo, ma-classify nyo if that is specific, if that is generic. Fortuitous event, sa lang yan, nawawalan ka lang ng obligation when the thing is specific. Pero kapag generic yan, wala kang takas. Bakit? Kasi makakahanap ka lang ng kapalit niyan. Bigas yan. Order ka sa kabilang store. Wala kang excuse pagdating sa generic. So yan, di ba? Mahalaga talaga yan. Malaman nyo kung ano yung different, kung ano classification ng thing. Ngayon, let's go to the to the effects of delay kapag creditor naman. So the creditor is guilty of breaching the violation. He is liable for damages is suffered by any debtor. He bears the risk of loss of the thing due. Ibig sabihin, Naamoy ko yung nilutong pritong manok ng nanay ko. Where the obligation is to pay money, the debtor is not liable for interest from that time. The obligation is to pay money, tapos inoferan na ni debtor. Ito na yung 1,000 na utang ko sa'yo. Pero sabi ni creditor, pabebe pa. Gusto ko yung crispy bill. Gusto ko yung galing sa bangko. Sabi mo, tarantado ka. Sabi ni debtor, ito na 1,000, maarte ka pa. Sabi ni creditor, gusto ko talaga yung galing sa bangko So in that case, loko-loko si creditor. Kahit na hindi na bayaran agad ni debtor yung 1,000 peso, pero dahil sa ang reason doon is hindi nag-accept si creditor because of unjustifiable reason, hindi required magbayad ng interest si debtor. Pabebe si creditor hindi tinanggap pa dyan yung 1,000 peso, choosy pa. Hindi mo maano si debtor nun. Kasi loko-loko si creditor. Lastly, the debtor may release himself from the obligation by consignation of or deposit in court of the thing or sum due. Ito na. Ano to, sir? Itong example, bahay. Isa sa uli na ni debtor yung bahay kay creditor. Si creditor ayaw tanggapin. Bahay yun, kapatid. Mahirap yun, pangalagaan. So, si debtor, isipin niya, paano to? Mayroon siyang option. I-deposit niya yun sa korte. O sabi niya, ay court, itong creditor ko ayaw tanggapin yung yung sinasauli kong thing. So, dyan muna ha. Deposit ko dyan. Consignation, tawag doon. Para si court, doon muna sa kanya. Siya yung siya muna yung mamahala doon sa bahay na yun. Oo. Sir, paano yan yung bayaran? Ngayon, paano yan, sir? Di ba may expenses yan pagdating sa ganyan? Pagdating sa ganyan, may expenses yan. Ngayon, pag nakita nila na si creditor may kasalanan, the expenses shall be paid by the creditor. So yan. Yan, sa pa yan sa extinguishment of obligation pa yung consignation or deposit. Pero yan, nasabi ko na agad ngayon pa lang. And lastly, compensation more, delay on the part of both parties in a reciprocal obligation. Legally speaking, there's no default delay. Delay of one part is followed by another. Simple lang kasi dito If the delay of one part is followed by that of the other, the liability of first infractor shall be equitably tempered or balanced by the court. May tinatawag tayo dyan yung kapag both parties are guilty, nakalimutan ko yung term na yun pero later on madadaanan natin yun. When both parties are guilty, negative sila, magkukwits yan. Wala silang mahabol sa isa't isa. Oo. When the both parties are guilty, magkukwits yan. Wala yan silang mahabol sa isa't isa. Ganun lang yung kasimple. Nakalimutan ko yun compensation mori ba yung tama? Basta may isang term pa yun. When both parties are guilty, wala silang mahabol sa isa't isa. Example, ikaw, nagbebenta ka ng drugs. Yung isang kasama mo, yung isang party, nagbebenta ng illegal weapons. O napag-usapan nyo, sige, exchange na lang tayo. Bigyan mo ko drugs, bigyan kita weapons. Illegal weapons. So, as you consider, both parties are illegal, di ba? Both parties are guilty. Bad faith. Kasi, contraband yung transactions nila So yan, wala silang mahabol sa isa't isa because both of them are guilty. So yan, mga ganong situations. Pero sa compensation mere, we're talking about delay lang for the both parties. Ngayon, di ba sabi natin kanina, the general rule, no demand, no delay. Take note, general rule. So may exception. So ano exception yan? When demand is not necessary to put the debtor in delay. Ibig sabihin, kahit na walang extrajudicial, kahit na walang judicial demand galing kay creditor, automatic may delay pa rin. Oo, ito yung mga example. When the obligation so provides. Diba sabi natin kanina, on January 15, babayaran na ni debtor kay creditor yung utang niya na 15,000. Yun, kailangan pa ng demand coming from debtor, coming from creditor. However, when the stipulation specifically provides that on January 15, babayaran na ni debtor yung 15,000 na utang niya kay creditor, and kapag hindi nabayaran ni debtor, then he will be automatically delayed without needing any demand. If there's a explicit provision in the contract, in the agreement, na hindi na kailangan ng demand, automatic HTFM, delay ka na. Kasi explicit may explicit provision when the obligation so provides. Second, when the law so provides. Pag yung batas na mismo nagsabi, kapag hindi mo binayaran on this day, delay ka. Example, taxes. Taxes. Sabi dito, April 15, dapat bayad ka na sa tax mo. Okay. Pag na-delay ka dyan, penalties yan kapatid. Penalties and surcharges, matataas yan. Pagdating sa taxation, sa remedies, ng tax remedies, tataas ng yan. Sa penalties and surcharges. Third, when time is of the essence. Ang usapan nyo, on January 15, pumunta kasi sa kay Red Ribbon. O kay Red Ribbon. Pag-usapan nyo, birthday ng kapatid ko sa January 15 ha. So, pa-deliver na lang tong ganitong karaming cakes ha. Ngayon si Red Ribbon, nagkaroon ng delay. Ngayon, kailangan pa ba ng demand dyan? Hindi. Kasi looking at the facts and circumstances surrounding the case, ang sabi, on January 15 na birthday ng kapatid ko. So, alam ni Red Ribbon na yung mga cakes gagamitin, kakainin sa birthday on January 15. Yun yung purpose ng cake. So, kapag hindi na comply ni Red Ribbon yun, automatic Hot FM, delay siya. Kasi aware siya eh. Alam niya na yung purpose ng cake na yon is for the birthday. Lumampas na January 16 na anong gagawin ng creditor ni ObliG doon sa birthday cake? Tapos na yung birthday. So, delay yun. Automatic delay. Legal delay sa part ni Red Ribbon, hindi na kailangan ng demand. Kasi alam na nga ni Red Ribbon na pang birthday yung cake. Next is when demand would be useless. Ano instances yan? Example, laptop, specific laptop, this serial number. Yeah. Ang sabi, on January 15, i-deliver ni seller kay buyer. Ang problema, nalaman ni buyer na yung specific unit ng laptop na pala yun, nasira ni seller on his own fault. Pag gano'n yung nangyari, bakit pa magdi-demand si buyer? Alam niya nang nasira yung nasira yung laptop, yung specific model na may specific serial number. Or, hindi na siya magdi-demand kasi alam niya nang sira yun. Useless na yung demand in that case. So, that is the fourth exception. When demand would be useless. And lastly, when there is performance by a party in a reciprocal obligation. Ito na, di ba? Sabi natin. Reciprocal obligation sa sale. Si seller, bebenta ng bigas, si buyer magbabayad ng 10,000. Ngayon, pag si buyer nagbigay na ng 10,000 pesos kay seller, tapos hindi pa nag-comply si seller, hindi niya pa binigay yung bigas, delay na siya. Kasi reciprocal obligation yan eh. Hindi yan one way, two way yan, bilateral, reciprocal. So pag gagawin na ng isa yung kanyang obligation, automatic HTPM gawin na nung isa yung kanyang obligation para hindi siya mag-incur ng delay. So yan simpleng-simple, delay. No demand, no delay. General rule. Exception, yung libang na mention natin. And may delay lang sa obligation to give and obligation to do, obligation not to do. Walang delay dyan kasi wala kang gagawin dyan. And a delay on your part, a legal delay on your part will not give you proper excuses. Pag kahit fortuitous event pa yan, pero na-delay ka before the happening of the fortuitous event, wala ka. GG ka kapatid. Ngayon, let's go to Article 1170. Article 1170 talks about provides that those who in the performance of their obligation are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor of the obligation thereof are liable for damages. Ito na. Damages. Diba? Pag sinasabi natin, kapag nag-incur ka ng loss, injury, and harm, loss, injury, may damages yan. And pag may damages yan, may civil liability ka. In this case, when those, sabi dito, kung sino yung may obligation to perform the obligation, guilty siya sa fraud, guilty sa negligence, guilty sa delay, and guilty sa hindi pag-properly follow ng stipulations ng obligation, liable siya for damages. So, these are the grounds for liability basically, which will entitle the injured party for damages for all kinds of obligation mentioned under 1157. Here, the breach of the obligation is voluntary. In Article 1174, it is involuntary. So, 1170, voluntary breach. 1174, involuntary. Ngayon, fraud. Ito yung sinasabi ng tatay niya kapag gumaduate yung anak niya. I'm so proud of you. So, fraud, deceit, or dolo. Fraud, deceit, or dolo. Take note, ito yung kanyang definition. It is the deliberate. Ito yung nagpapano sa kanya eh. When there's a deliberate or intentional, sinadya. evasion, pag-iwas sa normal fulfillment ng obligation. Deliberate, intentional evasion from the normal fulfillment of the obligation. Now, that is a ground for damages. Bakit? Because, dito, deliberate, intentional. So, makita mo, there's a malice. There's a dishonesty on the part of the doer. Kasi, hindi mo pwede sabing mistake yan. Hindi mo pwede sabing error yan. Sinadya niya eh. So, with that, wala siyang magawa. Kailangan niyang pagbayaran yung damages na na-cause niya. Like sample dito, you are obliged to deliver a whiskey, 40-year-old whiskey in this particular brand. Pero ang dineliver mo, whiskey na bagong gawa lang of this same particular brand pero bagong gawa lang. Yung inaano is yung 40-year-old whiskey. Ang binigay mo yung bagong gawa lang. So there is fraud. Sinadya mo. And considering na sinadya mo, there is fraud. Hindi mo, sinadya mong ibahin yung i-deliver mo para makatipid ka, para mas malaki yung ginansya mo. Di ba? Ngayon, take note, ang pinag-uusapan natin dito is incidental fraud. Incidental fraud. Dalawa kasing types meron Dolo causante and dolo incidente. Incidental fraud and causal fraud. Sa incidental fraud, yan yung topic natin dito. It talks about committing fraud in the performance of the obligation. Kaya dolo incidente, incidental fraud happens during the compliance of the obligation. Kasi we're talking about the compliance of obligation here. Yung causal fraud, yung dolo causante, it is a fraud that was performed to get the consent of the other party. Niloko mo yung other party para pumasok sa isang obligation. Oo, pag-usapan natin yan sa contracts because that will vitiate the consent. So, anong difference sila? Ulitin natin. Incidental fraud, it talks about the compliance. Ibig sabihin, meron na kayong kontrata at the first place. Meron ng kontrata, meron ng obligation. Kaso, ang ginawa mo, you committed that fraud in the performance of the obligation. Pagdating kay dolo causante, ang ginawa mo dyan, niloko mo yung other party para pumasok sa kontrata. Niloko mo. Sabi mo, pag pumasok ka sa kontrata na to, ito yung kikitain natin. Pero yun pala, in real life, wala kayong kikitain. Diba? Sinidus mo siya. In-induce mo siya na, pasok ka dito. Niloko mo basically. Para lang ibigay niya yung consent niya para magkontrata kayo sa isa't isa. So take note, we're talking about incidental fraud here. The fraud committed in compliance to the obligation. So naman, next is the negligent or culpa, fault or culpa. Dito naman, ito para siyang nakababatang kapatid ni fraud. Bakit si fraud? Kasi si fraud may malice may dishonesty. Pagdating kay negligence, this is any voluntary act or omission, there being no bad faith or malice. So yun lang kay yun lang kay negligence. Wala kang bad faith, wala kang malice. Pero voluntary siya, which prevents the normal fulfillment of the obligation. So yun lang kay negligence And usually kasi si fraud, pag nag-commit ka ng fraud, meron kang criminal liability dyan, hindi lang civil liability. Oo. Pagdating kay negligence, civil liability lang yan. Negligence lang yan The third ground for damages is delay, na pag-usapan natin yan. And lastly, contravention of the terms of the obligation, meaning hindi mo sinunod. Meaning hindi mo sinunod kung ano yung pinag-usapan nyo. The contravention must not be due to a fortuitous event or force majeure. Ito, distinguishment of fraud and negligence. In fraud, there's deliberate intention to cause damage or injury. Sa negligence, wala kang intention Pangalawa, waiver of liability for future fraud is void. Ito, future fraud. Ito, sabi ko ngayon pa lang, waiver of liability for future... na-stuck. Muntik na yun. Waiver of liability for future fraud, bawal. Pero waiver of liability for past fraud, pwede. Kasi meaning nun, pinatawad mo yung nag-fraud sa'yo. Oo. Past fraud, pwede mo i-waiver yung liability. Kasi basically, pinatawad mo eh. Pero future fraud, sabi ng batas, bawal yan kapatid. Ito, waiver for certain, sa negligence naman, pwede kang mag-waiver dyan. Oo, lalo na sa sales, meron yung topic doon na kung saan kahit na may kasalanan si debtor, basta kahit na may negligence on the part of the seller, yung negligence niya, pwede nyo pa rin i-waiver yun kahit na future negligence yun. Basta pinag-usapan sa kontrata, madadaan yun sa sales. And lastly, not lastly, fraud must be clearly proved, meaning, kasi di ba sabi natin, it has the criminal liability and civil liability. So, with that, alam natin na it must be proved. Tawag dito? Clearly proved meaning, tawag dito? Beyond reasonable doubt. Pagdating kay negligence, since civil liability lang yan siya, preponderance lang yan. Preponderance of the evidence lang yan. Lastly, liability for fraud cannot be mitigated or reduced by court. Bakit? Kasi intentional mo yung ginawa eh. May kasalanan ka. Intention mong mag-harm. Intention mo mag-cause ng loss to other persons. Bakit babawasan yung liability mo? Hindi, di ba? Napaka unsettling. And while liability for negligence may be reduced according to the circumstances. Now, let's go to Article 11. Pagdating natin ng page 64, 5 minutes break ulit. Pagdating natin ng 1173, 5 minutes break ulit kasi naihi na naman ako. So, 1171 sabi dito, responsibility arising from fraud is demandable in all obligation. Any waiver of action for future fraud is void. So, provision, klaro naman to. But take note, this is only for incidental fraud. So, demandable yan. Responsibility arising from fraud can be demanded, all kinds of obligation. Ito, nasabi natin to, waiver of action for past fraud. Past fraud, valid kasi basically pinatawad mo. Future fraud, hindi, bawal yan. So, let's go to Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable. Pero yung liability niyan may be regulated by the courts according to the circumstances. Kasi pagdating sa fraud, yung liability cannot be regulated by the courts. Bakit? Kasi nga, intentional mong manakit. Intention mong mag-cause ng harm, loss, injury sa other party. Pagdating sa negligence, wala kang ganong intention. Wala kang ganong intention. So, pwedeng ma-regulate, pwedeng ma-mitigate ng courts yung liability na matatanggap mo. So, in the performance of every kind of obligation, the debtor is also liable for damages resulting from negligence. Sa waiver, pwede yan sa negligence, whether past negligence yan or future negligence. Ngayon, when the negligence shows bad faith, meaning you have a deliberate intention to harm the other person, then it is equivalent to fraud. So, take note ha. Pag yung negligence with bad faith, it is equivalent to fraud. Oo, kasi you have bad faith eh. Ibig sabihin, you have an intention to harm, to cause injury, to cause loss. Bad faith tawag dyan. Kinds of negligence according to the source of obligation. Ito na mention natin ito. Contractual negligence, culpa contractual, culpa alquiliana, culpa criminal. Oo. Sa culpa contractual, from the word itself, contractual negligence in contracts resulting in their breach, culpa contractual yan. Civil negligence, culpa aquiliana, or negligence which by itself is the source of an obligation between the parties. Tawag dito yung tort or quasi-delict. Tort or quasi-delict. Criminal negligence naman, culpa criminal or negligence resulting in the commission of crime. So yan, civil liability, but also talks about the payment of damages for civil liability that arises from crime. So, etc. etc. Ngayon, ito, maganda to. Okay, to effect of negligence on the part of the injured party. So, paano to? Yung injured party, may negligence din on his part. So sir, pag ano yung nangyari, manenegate ba yung civil liability na babayaran sa kanya ni guilty party? Depende kapatid. Depende on the two circumstances. Pag yung negligence ng injured party was the proximate immediate cause kung bakit siya na-injured, kung bakit siya na-harm, kung bakit nag-cause sa kanya ng loss at the first place, he cannot recover damages. Bakit? Kasi meaning yan, siya mismo yung gumawa ng injury sa sarili niya. Siya yung So he cannot recover damages from the other party kahit na may negligence yung other party. Kasi yung negligence ng other party, basically naging correlation lang yun eh. Yung negligence na ginawa niya sa sarili niya, kaya siya na-injured, kaya siya na-damaged, causation yun. Yun yung naging reason. Proximate immediate cause. On the other hand, when his negligence is only correlated to the injury, to the harm, to the loss that he has suffered, yung proximate immediate cause, yung causation talaga nun is nanggaling sa immediate sa guilty party, then what can only happen here is mababawasan lang yung civil liability na babayaran sa kanya ng guilty party. So take note Take note. Ano yung naging cause ng injury sa injured party? Sarili niya bang kagagawan or kagawan ng ng guilty party? Kung sarili niyang kagagawan yun, big sabing causation, he cannot recover damages. Pero kapag kagagawan yun ng guilty party, yung ginagawa lang ng negligence ni injured party is correlated lang sa kanyang injury, ang mangyari lang, yung civil liability na babayaran ni guilty party, babawasan lang yan, mitigate lang yan ng korte. So yan tingnan nyo kung ano yung naging cause ng injury. Ganun lang kasimple. Tapusin ko nga itong 1173, then CR break ako ulit. Mahirap magturo pag nag-ihi. So, Article 1173 provides that the fault or negligence of the obligor consists in the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and the place. When negligence shows bad faith, the provisions of 1171 in the law of contract does not, if the law of the contract does not state the diligence which is to be observed in the performance that which is expected of a good father of the family. Ito, na-discuss natin ito, negligence kanina, yung preservation of the thing. Kapag silent yung contract, automatic diligence of a good father of the family, also known as ordinary diligence. Pero if the law specifically states that extraordinary diligence or a particular set or standard of diligence ang kailangang i-perform, kung anong sabi ng batas, yun yung masusunod. So, ito, meaning of fault or negligence as defined by the provision above. Yun. Consists of in the omission of the diligence which is required by the nature of the obligation. Pero according to the Supreme Court, in the case of United States versus Barrias 23 Field 44, ito, ibig sabihin matandang Supreme Court decision to. Kasi panahon pa to ng 23 Field, mga 1940s to 1950s. So, 23 Field 44. So, sabi ng Supreme Court, negligence is the failure to observe for the protection of the interest of another person that degree of care, precaution, and vigilance which the circumstances justly demand whereby such other person suffers injury. So, ibig sabihin, wala kang pake sa taong nakapaligid sa'yo. Dahil wala kang pake sa taong nakapaligid sa'yo, dahil wala kang pake sa interest ng ibang tao, hindi ka nag-exercise ng proper conduct, ng proper manner, and because of that, the other person has suffered injury, loss, or harm. Sabihin, wala kang pake. Ganun lang yung basic, simpleng definition ng negligence. Hindi mo ginawa kung ano yung dapat mong gawin. And because of that, may taong nasaktan. May taong nawalan. May taong na-injured. Now, factors to be considered. Ngayon, gaya na sabi natin kanina, negligence, paano yan madidetermine, sir? May set of standard ba yan? Hindi. Depende sa circumstances. Kung kailan mo masabing may negligence or part yan. For example, ito, the following factors must be considered. Nature of the obligation. When you're carrying materials that is known to be flammable, maninigarilyo ka ba? Hindi. Alam mo nang flammable yan eh. Masusunog yan. Pag naninigarilyo ka habang ginagawa mo ang trabaho mo, negligence yan on your part. Ito, circumstances to the person. A guard. A prime in his life. Parang robust and healthy. Nakatulog while on duty. Negligence yan on his part. Kasi nakalagay specific na prime of his life. Robust and healthy. Ibig sabihin kayang-kaya niya yung trabaho. Pero nakatulog while on duty. Diyos ko. Negligence yan. Next, circumstances of the time. Ito yung mga walang hiyang tricycle dito. Walang headlights tuwing gabi. O negligence din on their part. Kasi pag gabi, kailangan mo ng headlights, kailangan mo ng ilaw. So that is a negligence in consideration of circumstances of time. Pag gabi, i-open mong headlight, delikado yan kapatid. And lastly, circumstances of the place. Sa highway, superhighway, mga SCTEX, SLEX, NLEX, Cavitex, driving at 100 kilometers per hour, required yan. Wala na pa sa fast lane ka, kailangan mo gawin. Required yan. Yan yung maximum, hindi ka pwede lumampas dyan. Pero pwede mong gawin. Pero kapag gagawin mo yan sa town, mag 100 kilometers per hour ka, Diyos ko, negligence yan. On the factor of circumstances of time. Measure liability of damages. Usually, it is preferably kapag korte ang magde-decide kung ano yung amount of damages. And ito, kinds of diligence required. Under Article 1173, the following kinds of diligence are required that agreed upon by the parties, orally man or in writing, in the absence of the stipulation that is required by law in the particular case. Kung sabi ng batas, extraordinary diligence, sundin mo. Pag sabi ng batas, ordinary diligence, okay, yun ang gawin mo. And if both contract and law are silent, then the diligence expected of a good father of family, or also known as ordinary diligence. Sir, napakahabang term sabihin ng diligence of a good father of family. Bakit hindi na lang ordinary diligence yung nilagay dyan sa book? Basically, kasi ganito yung reason. Simple ng reason bakit diligence of a good father of a family ang ginamit na term. Para to remind the person on how a father should take care of his family. O to remind him na ordinary diligence, na ganito dapat yung way ng pagprotekta mo sa interest ng pamilya mo. Sa interest ng sarili mong property. Kaya nilagay dyan, diligence of a good father of a family to remind the people. Kaya yun ang ginamit na term. So with that, 5 minutes break, naihi talaga ako. Dali na lang man to, mga 20-30 minutes na lang to. So yun, ihi muna ako. Bye-bye. Balik lang. 5 minutes. Tok na rin kayo, no? Sarap mag-siesta, no? Ito, madali na lang man to. Kasi mutuo, wala naman to. Presumption. Hindi naman to malaga tong last parts. So yun. So may nagtanong dito sa chat about 4327. Chill lang. Ngayon pa lang tayo darating sa 4327 kasi 1174 siya. So, di ba na-mention naman natin kanina, pagdating sa 4327, kapag nauna yung legal delay, then nangyari yung 4327, wala kang excuse, no? Nasabi natin kanina. Ngayon, ano ba itong 4327? Now, 4327, according to Article 1174, except in cases expressly specified by law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen or which though foreseen were inevitable. So ano yan? So muna, ano ba itong meaning ng 4327? In any event which cannot be foreseen or which even it can though foreseen is inevitable, parang si Thanos, no? Yan yung mga 42 event. Yung hindi nating alam mangyayari, for example, earthquake, or alam nating mangyayari, pero hindi natin may iwasan, inevitable, for example, yung paparating na bagyo, si Auring. Mga storm, alam natin mangyayari yan. Pero maiwasan ba natin? Hindi. Alangan, i-move natin yung Pilipinas papalayo sa bagyo. Hindi naman siguro. Diba? Which cannot be foreseen. Example, earthquake, mga tsunami, kidlat, or even though foreseen, is inevitable. Mga bagyo. Hindi natin alam naman natin darating na yung bagyo, pero hindi natin maiwasan. Now, stated otherwise, it is an event which is either impossible to foresee or impossible to avoid. Now, the essence of fortuitous event consists of being an happening independent. Ito ang importante. Para ma-excuse si debtor. This fortuitous event must be independent. The happening of which must be independent of the will of the debtor, and which happening makes the normal fulfillment of the obligation impossible. So yung general rule dyan, if because of fortuitous event, which is independent of the will of the debtor, and the happening of which makes the fulfillment of the obligation impossible, then si debtor may excuse sa fulfillment ng obligation. Yun yung general rule. Pag may fortuitous event na dapat independent sa will ni debtor, and the happening of such fortuitous event makes it impossible for the debtor to comply with the obligation, then the debtor is excused from complying with the obligation. Yan yung general rule. Later on, pag-usapan natin ang exceptions. Kasi just because may fortuitous event does not necessarily mean na excuse ka. Ma-extinguish yung obligation mo pagdating sa exceptions. Now, fortuitous event distinguished from force majeure. A fortuitous event may be either an act of man or act of God. Act of man, strictly speaking, fortuitous event is an event independent of the will of the debtor, but not of other human wills. So yan yun, like war, fire, robbery, murder, insurrection. Basta, ang mahalaga, independent of the will of the debtor. Pagdating naman sa acts of God, they refer to what is called majeure, or those which are totally independent from the will of every human being. Ganyan sabi, earthquake, flood, rain, shipwreck, lightning, eruption, volcano, bagyo, tornado, typhoon. Sa batas natin, fortuitous event and force majeure are identical. Pareho natin ginagamit. So pag marinig kay force majeure, isipin nyo na, fortuitous event yan. Basta ang mahalaga, whether that's act of man or whether that's act of God, ang mahalaga dyan, it must be independent of the will of the debtor. Wala siyang kinalaman dyan. Para credible siya para maging credible siya para ma-extinguish yung kanyang obligation. Now, there are two types of fortuitous event according to our civil code. Yung ordinary fortuitous event or those events which are common and which the contracting parties could reasonably foresee. And yung extraordinary events or those events which are uncommon and which the contracting parties could not have reasonably foreseen. Example given, earthquakes, fire, pestilence, mga classifications lang yan. Ngayon, kailan natin masasabi na itong particular event is a fortuitous event? May requisites tayo. Una, the event must be independent of the human will or at the very least, gaya na sabi natin kanina, independent of the will of the debtor. Basta walang kinalaman si debtor sa happening ng event na yan. Second, the event could not be foreseen. Or, if it can be foreseen, inevitable. Hindi natin ma-avoid. So, dalawa yan impossible to foresee or impossible to avoid. Thirdly, the event must be of such character as to render it impossible for the debtor to comply with his obligation in a normal manner. And lastly, the debtor must be free from any participation in or the aggravation of injury to the creditor, that is, there is no concurrent negligence on his part. So, an example niyan. Example. Tawag ito. Na mental block tayo. Example. Mayroon ka, kailangan mo mag-deliver ng kaban ng bigas, malaking shipment, sa from Mindanao to Luzon. Kaso, habang papaano yung barko, kung saan mo pinadeliver yung kaba ng bigas, yung shipment, lumubog yung barko. Lumubog yung barko. Ala Diyos ko. Paano yan? Paano yan? May excuse ka. May excuse ka as long as wala kang participation. Kasi hindi mo ma-foresee na lulubog yung barko. Oh, hindi mo man ma-foresee na lulubog yung barko. Wala kang kasalanan. 42.7 yun. Or example, paparating yung bagyong Auring. Di ba? Yung sa Shopee, di ba? Madidelay. Madidelay talaga yung mga packages natin. Kasi alangan naman pasuungin mo sa masamang panahon yung mayroong mga eroplano, yung mga barko. Kawawa naman sila. So yan, na-excuse sila. Oo, basta may 42.7 na independent of the will of the debtor, may excuse yan sila. Ngayon, let's go to the rules as to the liability in case of a 42.7. A person is not, as a rule, responsible for loss or damages caused to another resulting from the non-performance of obligation due to 42.7. Yun yung general rule. The obligation is extinguished. Oh, because of 42.7, yung bagay na kailangan mo deliver, specific cellphone, may serial number 1234711, because ninanakawan ka, robbery. Habang papunta ka sa sa meet-up nyo sa need pa proof. Oo, need yan. Lalo na sa may nagtanong dito, need po proof na di involved for 42.7 na acts of man. Ganito kasi sa batas natin. If ikaw yung nag-assert, if ikaw yung nagbibigay ng claim, the burden of proof nasa'yo. Kailangan mong patunayan yan. Kailangan mong patunayan yan. The burden of proof is nasa'yo. Pag ikaw yung nag-claim, ikaw yung nag-assert, sabi mo, ganito, wala akong kasalanan. Oo. Kailangan mong patunayan yan. In this case. O kapag nasabi mo, wala akong kinalaman dyan. Baka yung sinasabi nyo? O in that case, since sinasabi mo wala kang kasalanan, kailangan mo patunayan yan. Na hindi ka involved dyan, hindi ikaw yung nag-utos. O, lalo na pag, na hindi mo kakilala yung gumawa ng acts of man na yan, hindi mo inutusan na pagnakawan yan, di ba? Hindi, walang inside job. Ganun. So, need proof? Oo. You need to, lalo na pag strong yung sa'yo strong against sa'yo. Ganito kasi sa justice system natin, kapatid. Kung sino yung nag-assert, kung sino yung nag-claim, the burden of proof nasa kanila. The burden of proof nasa kanila, sa plaintiff. Kung sino yung nagsampa ng kaso. Yung defendant, ang gagawin niya lang, titingnan niya, tatansyahin niya yan. Ganito yung sa justice system natin. Nabulol ako. Nabulol.
Tansyahin, sir.
Oo, nabulol. Nabulol mo. Nasabi ko yung first. Kailangan ko. He will assess, pa-socially na natin. He will assess kung yung proof na present ng plaintiff, ng prosecution against him, he will assess if enough ba yun to prove he's guilty, to prove na guilty siya. Pag na-assess niya na, mukhang dehado tayo dito, tsaka yan siya maglalabas ng mga evidence to prove his innocence. In this case, sabi dito, itong need po proof sa di involved 42.7, usually mangyayari lang yan kapag inaccuse ka na involved ka. Kapag hindi ka inaccuse na hindi naniniwala na sinabi mo na hindi naniniwala yung plaintiff, yung prosecution na hindi ka involved, pag hindi sinabi mo hindi ako involved yan bakit niyo ako pag hindi sila naniniwala, inaccuse ka nila na involved ka, okay, tsaka ka lang ng evidence. Tsaka mo lang i-prepare yung evidence mo. Kasi baka may papakita sila, i-present sila na kailangan ready ka. Pero kapag hindi ka naman nila inaccuse, kasi on their own, na nila na, di naman pala to siya involved wala naman siyang kinalaman kung bakit nangyari yung 42.7. Then, you don't need to, hindi mo na kailangan mag-present ng evidence. May nag-raise ng hand? Si Marjorie. Yes, Marjorie. Nag-raise siya ng endo. Girl? Ay, binaba niya. Nahiya siya. Huli. So yun. Basta ganun, that's how our justice system work. Kung sinong nag-accuse, sila yung may burden of proof. Si defendant, i-assess niya lang yan. Girl, ano ba talaga girl? Ano man, ba't ka nag-resend? Okay. So, yun. Kung tsaka mo lang, tansyahin mo lang. Yun! Yes! Tansyahin mo lang kung enough ba yung evidence ay present ng prosecution to convict. Hoy, to convict you. So, next. Diba sabi natin, ang general rule, kapag nangyari yung fortuitous event, then it makes it impossible for you to comply with the obligation, then your obligation is extinguished. Yun yung general rule. Since general rule yan, may exception. Ano yun? When expressly provided by law. In exceptions ABC, below the special strictness of the law is justified. Yung una, the debtor is guilty of fraud, negligence or delay or contravention of tenor of the obligation. Meaning yan, before pa mangyari yung fortuitous event, the debtor is already guilty of fraud, negligence, delay, or contravention of the tenor. Then, the happening of the fortuitous event, hindi na pwede gawin niyang defense to extinguish his obligation. But take note, such fraud, such negligence, delay, or contravention to the tenor, dapat before yan nangyari yung fortuitous event. Oo. Before nangyari yung fortuitous event. Para maging, para hindi siya ma-extinguish yung kanyang obligation. Next is the debtor has promised to deliver the same specific thing to two or more persons who do not have the same interest. Ito yung na-mention natin kanina. Kapag ikaw seller, nag-promise ka to deliver a thing, to deliver, let's say, sinandoming rice to two persons, wala namang particular designation yan eh. So, hindi mo yan i-consider mo yan as a generic thing. So, kahit na pinamis mo yan sa two buyers, wala kang kasalanan. However, pag yung prinamis mo is a specific determinate thing, doon ka na magkakaroon ng kasalanan. Kasi alam mo nag-iisa lang yan. Bakit mo ipapromise sa dalawang tao? Nag-iisa lang yan kaya specific. So in that case, kahit na mangyari yung fortuitous event, hindi ka-excusable. Hindi ma-extinguish yung obligation. Bakit? Kasi pinamis mo yung isang bagay sa dalawang tao, may guilty ka. What if hindi na-happen yung fortuitous event? Di ba? Pinamis mo yung isang bagay sa dalawang tao, may kasalanan ka. Kanino mo ibibigay yan? Paano yan? Oo. So, yun yung point. Bakit? Kahit na nangyari yung fortuitous event, pero pinamis mo yung same thing, specific thing to two or more persons, you are still considered to be guilty. Your obligation is not extinguished. Ito naman, the obligation to deliver the obligation to deliver a specific thing that arises from a crime. Example, nag-snatch ka ng cellphone, nahuli ka, so pinapasa uli sa'yo yung cellphone, pero nawala mo because of a fortuitous event, nasunugan ng bahay nyo, like po ganon, kasi nandoon yung cellphone na ninakaw mo. Kahit na nangyari yung fortuitous event na yun, hindi ka excusable from your obligation. Bakit? Because that obligation arises from crime. Kailangan mo isauli yung ninakaw mo. At the first place, guilty ka na at the first place. Oo, bad faith ka na at the first place pa lang. So, hindi ka excusable. And the thing to be delivered is generic. Ito na sabi natin. Kahit na fortuitous event yan, pero yung bagay is generic, is indeterminate, hindi pa rin ma-extinguish yung obligation mo. Kasi generic yan Pwede ka pang kumuha sa ibang supplier. Pwede ka pang kumuha sa ibang source. So, pag generic yan, kahit na nawala in a fortuitous event, loss of thing, since generic yan, makakuha ka pa sa ibang supplier, sa ibang sources. And lastly, when declared by stipulation, so pag sinabi ng party sa kanilang kontrata na kahit na magkaroon ng fortuitous event that causes the loss of the thing, hindi pa rin ma-extinguish yung obligation, then yun ang masusunod. Bakit? Because the basis for this exception rests upon the freedom of the contract. Pangatlo, when the nature of the obligation requires the assumption of risk. Ito, assumption of risk. Basically, ina-assume nyo dito na pwedeng magkaroon ng risk, pwedeng magkaroon ng loss, pwedeng magkaroon ng injury, pwedeng magkaroon ng harm. So because of that assumption, tapos nangyari yung fortuitous event, hindi mo pwedeng excuse yung iyong sarili from complying with the obligation. Example, sa insurance. Ang insurance mo, kapag na-aksidente ka, sagot ng insurance yung bayad. Ngayon, na-aksidente ka, fortuitous event yan. Alangan, aksidente. Cannot be foreseen. Aksidente yan. Ngayon, na-aksidente ka. Sasabihin ba ng insurance, oy, fortuitous event yan ha? Sabi ng batas, hindi namin babayaran. Loko. Assumption of risk yan, insurance yan, nature yan ng insurance. Hindi yan excusable. So, yung obligation ng insurance to comply with the obligation para iano siya yung insurance premium mo, hindi mawawala. Kasi assumption of risk yung nature ng insurance. Yun. Now, let's go to, patapos na tayo. 1175, medyo hindi na to hindi na to importante kasi wala tayong usurious law, usury law. Ano ba tong usury law? Dati kasi, kapag magpapataw ka ng interest rate, merong maximum yan. 12% ata dati. O bakit? Para hindi masyadong masakit sa bulsa. O para hindi ba abusado. Ganun. But now, tinanggal na yung usury law na yan. So sir, since tinanggal yung usury law, may freedom na ang mga contracting parties kung anong interest rate ang nilagay nila? Oo, may freedom na sila. So sir, absolute freedom yan? Hindi. May exception. Ano yun? As long as it is not iniquitous or unconscionable. Ibig sabihin, hindi OA. Hindi yung grabe mapanakit. Hindi yung grabe masakit sa bulsa. Yung reasonable lang. Kaya nalagay dito, iniquitous or unconscionable. Dapat, hindi OA, hindi sobra-sobra. Oo. Dapat yung reasonable. So, they have the freedom kung ano yung interest rate na gusto nilang gamitin. Pero, wag yung sobra. Wag yung nakakapatay na, hindi man nakakapatay. Yung gusto mo nang patayin yung sarili mo dahil sobrang laki. So, usury is contracting for or receiving interest in excess of the amount by law, or loan, usury law, hindi na yan dahil tinanggal ang usury law, wala na yan. Ito, presumption, according to 1176, the receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as to... Wala, natapakan ko po sa... Natutulog siya. Shh. Sa ilalim pala siya. So, the receipt of a later installment of a debt without reservation as to prior installment shall likewise raise the presumption that such installment is or have been paid. So, ang presumption, basically it meant the inference of a fact not actually known arising from its usual connection with another which is known or proved. So, presumption meaning lang yan, nag-assume ka based on the facts na alam mo. But take note, assumption lang yan, presumption lang yan, it is rebuttable. It is, before that, let's go to two kinds of presumption. Una, conclusive presumption, one which cannot be contradicted, like the presumption that everyone is conclusively presumed to know the law, Article 3, na mention Article 3 of the Civil Code yan. Ignorance of the law excuses no one from compliance therewith. Conclusive presumption. Basically, itong conclusive presumption kasi is, more on ito yung pinataw. Basta ganun yung sistema niya. Pupunta naman sa disputable presumption or rebuttable, ibig sabihin, you can dispute it, you can contradict it, one which can be contradicted or rebutted by presenting proof to the contrary, like the presumption established under Article 1176. So ano yan? Like example, nakita mo yung boyfriend mo may kasamang babae. So anong assumption mo dyan? Anong presumption mo? Nang bababae siya. Hindi ka sure na nang bababae siya kasi pinipresume mo lang. Pero because of the fact na nakita mo may kasama siyang babae, yun yung basis ng presumption mo. So yung naging assumption mo, nang bababae yung sota mo. Ganon yung presumption. Pero, mako-consider mo siya ba as conclusive? Di mo alam, pinsan niya pala yun eh. So, masasabi mong disputable yan or rebuttable. Yan, presumption na to. As provided sa 1176, with reservation to the interest, di ba? Pag nagbabayad kasi ng utang, lalo sa mga bangko, pag mangungutang ka, may interest yan. Ngayon, ang assumption kasi is, pag magbabayad ka ng utang mo, ang unang binabayaran is interest. Pag bayaran ng interest, tsaka yan i-apply sa principal amount. Ngayon, kapag dito, sa 1170 na, nag-turn yung page. Kapag the receipt to the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that the interest. Kapag ang nangyari, nag-receive si creditor ng utang na binayaran mo, ang assumption dyan is pag walang reservation sa interest, clearly naman yung sinabi ng batas ang assumption dyan, ang presumption dyan is nabayaran ng interest. So, ina-apply na lang sa principal. But that can be rebutted, that can be disputable. Pag sa installment naman, kapag yung installment, nag-issue ka ng receipt for the month of April, then ang assumption yan, yung previous month, yung presumption yan, yung previous months, nabayaran na. Pero, presumption lang yan disputable yun. So, ganyan naman yung sinasabi dito payment of taxes. Pero pagdating sa payment of taxes, walang presumption. Basta magbayad kayo ng taxes nyo, mataas ang surcharges, mataas ang penalties. Non-payment proven, basta simple lang naman presumption. Ito, second to the last article. 1177, the creditors after having pursued the property in possession of the debtor to satisfy their claims may exercise all the rights and bring all the actions to the latter for the same purpose save those which are inherent in his person. They may also be impugn the acts which the debtor may have done to defraud them. Ito na yung sinasabi natin. Article 1177, ito importanteng article ta. Article 1177 talks about remedies ni creditor para masatisfy yung kanyang claims. Now, may mga certain steps siya na pwedeng kunin. In case the debtor does not comply with this obligation, the creditor may avail himself of the following remedies to satisfy his claim. Una, exact fulfillment. Ito, napag-usapan natin kanina, diba, remedies. Exact fulfillment or specific performance with the right to damages. Second, pursue the leviable. Ibig sabihin, ma-levy. Sir, ano yung levy, sir? Yung sa attack on Titan, Ben, sir? Ang meaning na ng levy, from the word leviable, ibig sabihin, papatawan mo. Parang, tawag dito? Parang kukunin mo yung property ni debtor. Parang ganun. Lilevy, usually korte kasi yan na ganun Parang i-acquire, kukunin yung property ni debtor. Para yung property na yon gagamitin pambayad. Levy. Oo. Pag hindi na-claim, pag hindi binayaran niya, ni debtor yung utang niya, hindi niya na-fulfill yung kanya yung i-fulfill, then kukunin yung pambayad na yon dun sa na-levy na property. Ganun lang kasimple si levy. But take note, yung mga property na pwede mong ma-levy is yung mga property lang na hindi exempt from attachment under the law. Yung attachment, yun na. Delikado yun pag na-attach yung properties mo kasi pag na-attach yung properties mo, meaning lang yung parang pinatawan yung the hands of the law holds that property. the hands of the court takes hold of that property. Pag na-attach ang property mo, hindi mo pwede yan gamitin. Hindi mo pwede mabenta yan. Hindi mo pwedeng isangla yan. Hindi mo pwedeng gawing mortgage yan. Hindi mo pwedeng gawing security yan. Para siyang na-freeze. Pag na-attach siya ng law, maraming mga business, pag na-attach yung mga machineries nila, yung mga properties nila, ang mangyayari dyan, hindi nila magagamit sa business nila, hindi nila mabebenta. Matetenga. Freeze. Bakit na? Freeze. Yun yung attach. Pag na-attach yung property, so delikado yan. So kaya bayaran yung mga utang nyo. Pag na-attach yung properties nyo, restricted. Anong pwede nyong gawin? Third is, after having pursued the property in possession of the debtor, exercise all rights, like the right to redeem and bring all actions of the debtor, like the right to collect from the debtor of his debtor, except those inherent. Dito muna tayo sa may mga certain properties kasi na hindi mo pwede ma-attach. Anong example, sir? Family home. Family home, yung bahay nyo, pag na-consider yan as a family home, hindi yan pwede kunin. Hindi, maraming cases tayo na, kasi kasi yung family home, noong 1987, 1986. So, maraming cases yan na inattach yung family home nila. So, nagiging consideration yan is, kailan naging family home yan? After 1986 or 1987 or before? Kapag before 1986, 1987, pwedeng ma-attach yan, pwedeng pambayad ng utang yan. Pero pag after 1986, 1987 yan, considered as family home, considered as excuse from attachment. Oo. Bakit? Family home yan bahay yan. Diyan tumitira yung tao. Hindi yan pwedeng paalisin. Hindi yan pwedeng i-attach sa pang-utang, pambayad ng utang yan. Diyan tumitira yung tao. Protection yan Sa pagpasok niya ng law, di-discuss yan. So, punta tayo sa pangatlo. After having pursued the property in possession of the debtor, ibig sabihin, nag-specific performance ka na. Hinabol mo na yung properties, na-levy mo na yung properties ni debtor. Anong next mong gagawin? Lalo na pag hindi enough yung properties niya. Oo, may mga instances kasi na hindi enough yung properties ni debtor pambayad sa utang niya. Now with that, after having pursued the property in possession of the debtor, exercise all the rights, like the right to redeem and bring all actions of the debtor, like the right to collect from the debtor of this debtor, except those inherent in or to the person of the latter, such right to vote, to hold office. Ano yan? Ano meaning yan? For example, yung debtor, merong creditor siya of another debtor. Ibig sabihin, may nangutang sa kanya. Yeah? He's a creditor of another debtor. Ngayon, pwede mong sabihin o pwede mag-file ng petition sa court na, instead na yung debtor na yun, magbabayad kay debtor number 1, idiretso na lang sa akin yung pambayad. Idiretso na lang sa akin kaysa idaan pa sa kanya. Para pandagdag yun sa pambayad ng utang niya. O ganun nakalagay ito. The right to collect from the debtor of his debtor. So instead na idaan pa sa kanya, baka hindi pa ipambayad baka itago pa, idiretso na lang sa akin yung pambayad. So, next is ask the court to rescind or impugn acts or contracts which the debtor may have done to defraud him when, ang tawag dito sa number 3 is action subrogatoria. Action subrogatoria. Oo, action subrogatoria yun. Oo, lalo na sa Latin. Lalo na sa Latin, yun ganito ko ta. Ito naman, sa number 4, ask the court to rescind or impugn acts or contracts which the debtor may have done to defraud him when he cannot in any other manner recover his claim. Tawag dito, action pauliana. Action pauliana. Yung isa, action subrogatoria, from the word itself, subrogate, substitute. Ito naman sa number 4, action pauliana. Ano meaning ito? For example, etong si debtor, may utang sa'yo. Then may property siya, may bahay siya. Ngayon, paparating na yung pambayad ng utang. Hindi siya makabayad ng, tawag ito? Paparating na yung due date na kailangan niyang bayaran yung utang. Kaso itong ginawa ni debtor, dinonate yung bahay niya sa kapatid niya. Kasi inisip niya, uy, since itong bahay na to, sa idodonate ko sa kapatid ko, so siya na may-ari, hindi na to pwedeng habulin ni creditor ko. Inisip niya, wais daw siya. Ang problema, ginawa niya yon to defraud his creditor para idenggoy ba yung kanyang creditor, para takasan yung kanyang liabilities. Hindi niya pwedeng gawin yon. Bakit? May tinatawag tayong action pauliana. Etong si creditor, pwede siyang pumunta sa korte. Uy, etong debtor ko, loko-loko, dinonate yung bahay niya sa kapatid niya para takasan yung obligation niya sa akin. Sabi ng korte, ganun ba? Rescind natin yan. Cancel the contract. So yung donation, cancel yun, balik yung ownership ng bahay kay debtor, yung bahay, pambayad na ng utang. Hindi pwedeng takasan niya ni debtor. Obligation niyang bayaran yung utang eh. So yan, action pauliana. So ito. Lastly, subject to the laws. All rights acquired in virtue of an obligation are transmissible if there has been no stipulation to the contrary. So ang general rule, all rights that are acquired in virtue of an obligation are generally transmissible. Ibig sabihin, matransfer mo siya. Pero yun yung general rule eh. So may exception. Ano exception? Una, prohibited by law. Second, prohibited by stipulations of the parties. So ito, when prohibited by law, like the rights in partnership, agency, and comodatum, which are purely personal in character. Personal in character. Why? Because of the doctrine of delectus personae. Delectus personae. Ano yan? Basically, ang delectus personae, it is the right of the person to choose whom he wants to be associated with. It is the right of the person to choose whom he or she wants to be associated with. Kung sino yung pwede niya ma-associate, karapatan niyang pumili. Sa partnership, karapatan niyang piliin sino yung magiging partner niya sa business. Sa agency, karapatan niya. Kasi ako comodatum, karapatan niya yan. That is why it is said, these are personal, purely personal in character. It is on the person itself. Kaya niya pinili yung tao na yan because of the person itself. Based on the doctrine of delectus personae. So, yun. By contract of partnership, two or more persons by themselves, contract of agency, contract of comodatum, yun. Pagdating dyan, example, partners kayo sa isang partnership, hindi mo pwedeng i-transfer yung pagiging partnership mo, generally, sa another person because yung ibang partners, pinili ka nila as their partner, hindi nila pinili yung other person. So, hindi mo pwede transmit yan, hindi mo pwede transfer yan to another person. Ikaw yung pinili nila eh, hindi siya. Ikaw yung pinili. Ano kaya sa feeling na no? Pinili ka. So, prohibited, second, prohibited by stipulation of the parties. Yun, pag sinabi ng parties na hindi sa transmissible, hindi sa transmissible. So yun yung end ng nature and effects of obligation. And with that, end natin yung discussion natin. So, after natin ma-discuss yung chapter 3, long quiz tayo. Kasi 2 meetings ang kailangan ng chapter 3 eh. Different kinds of obligation to, mahaba to. So, sir, anong coverage ang next meeting? Kung ano yung nakalagay sa syllabus natin, yun yung pina-follow natin. Pina-follow natin kung ano yung nakalagay sa syllabus. So, for next meeting, kung ano yung nakalagay sa syllabus, yun yung coverage. Then, para sa CFAS nyo bukas, automatic magpo-post yung question. Google form pa rin. Automatic magpo-post yung question sa Google Classroom. Then, 1 p.m. Then, mag-stop siya since naging brave yung iba sa inyo. Mag-stop siya. Deadline niya is 2:30 p.m. Tiris lang man yun siya. Multiple, secret na lang kung ano yun. Tiris lang naman yun siya. Alangan, CFAS lang to eh. Wala tong problem solving. Tiris lang to. And, yun, buti sumabay yung section B sa atin kasi ayoko kayo disturbohin sa, long weekend tayo ngayon na, 25, 26. Thursday, Friday. So, tapos weekend, long weekend tayo. So, buti na lang sumabay kayo ngayon kasi ayoko kayo disturbuhin sa rest nyo during the holidays. So, with that, yan yung end ng session natin. And don't worry, ipopost ko yung lecture, yung recorded video mamaya. So, with that, yes, makakain ko na yung fried chicken. Bye-bye!
Thank you, sir.
Thank you, sir. Salamat, Master. Thank you, sir. Thank you, sir.
Bye, sir.
Bye po.
Thank you, sir.
Thank you, sir.
Yung sir, yung.
Thank you, sir.
Bye, sir.